All right. Good afternoon, everyone. My name is Caitlin Shugart-Schmidt, and I am the current editor-in-chief of the George Washington Law Review. And I am delighted that each of you has been able to join us this afternoon to kick off our 2017 Symposium, The Challenge of Crime in a Free Society, 50 Years Later. Building on the outcomes of the 1967 Commission, speakers today and tomorrow will provide new insights on the path forward for criminal justice reform. To begin with, I'd like to welcome our symposium co-host, Dean Fairfax, who will introduce this afternoon's wonderful keynote speaker.
Thank you, Caitlin, and welcome. Again, my name is Roger Fairfax, and I'm the Senior Associate Dean for Academic Affairs and Professor of Law here and Director of the GW Criminal Law Initiative. But most relevant is my role as co-sponsor with the splendid George Washington Law Review. And so I want to ask everyone to join me in a round of applause for Caitlin, Jill, and the symposium editors. And I want to thank you all for being here, too. There's much to be said later about this symposium and its significance, but let me get right down to business here at the outset. And it's my distinct honor to introduce our opening keynote speaker, Chief Judge Patti B. Saris of the U.S. District Court for the District of Massachusetts and immediate past chair of the United States Sentencing Commission. After graduating from Harvard Law School, Judge Saris clerked for the Massachusetts Supreme Judicial Court and then went into private practice. When the legendary Senator Edward Kennedy became chairman of the Senate Judiciary Committee, Chief Judge Saris moved to Washington, D.C. and worked as his staff counsel. She later became an assistant United States attorney and eventually rose to be chief of the civil division of the office until 1986, when Judge Saris became a United States magistrate judge, and then 3 years later became an associate justice of the Massachusetts Superior Court. In 1994, she was appointed by President Bill Clinton to be a district judge on the United States District Court for the District of Massachusetts and became chief judge of that court on January 1st, 2013. She was nominated by President Barack Obama and confirmed unanimously by the United States Senate to serve as chair of the United States Sentencing Commission and served in this capacity from January 2011 to January 2017. Chief Judge Saris' tenure as chair has been widely recognized as one of the most successful and impactful in the history of the U.S. Sentencing Commission. Under her leadership, the commission tackled many difficult issues, and Judge Saris' leadership is credited for, among other things, the significant reduction in the prison population on the federal level, the implementation of the historic and bipartisan Fair Sentencing Act of 2010, which reduced the crack powder sentencing disparity, and the reduction in guidelines levels for certain narcotics offenses and making those changes retroactive. On a personal note, I had the high honor of clerking for Chief Judge Saris, then Judge Saris, on the U.S. District Court in the late 1990s. And it was the court's first year in the then brand new, beautiful federal courthouse in Boston. If you haven't been there, you should visit. It's on Fan Pair. It's wonderful. And that clerkship was one of the most formative professional experiences I have had to date. To see her brilliance on display, both on the bench and in chambers, and to see the respect she commanded from fellow district court judges, judges on the U.S. Court of Appeals for the First Circuit, and the Supreme Court justices who, when they would visit Boston, would drop by chambers, was truly enthralling. And it was a special treat for myself and my co-clerk. And my co-clerk and I certainly learned about the ins and outs of subject matter jurisdiction and jury instructions and the, at the time, brand new federal habeas statute, what good lawyering looked like and what not so good lawyering looked like from the vantage point of a judge. And it was almost like another 3 years of law school rolled into 1 year of clerking. However, we learned just as much from the way that Judge Saris treated everyone she encountered, regardless of their station. from the way she respected the dignity and humanity of convicted defendants, even as she prepared to impose upon them significant sentences of incarceration, to the way she treated everyone in the same way, from fellow judges and attorneys, courthouse staff, clerk office staff, and custodial staff, and to the way she showed patience and grace when a young lawyer was struggling through an argument in her courtroom in a difficult case. All of those lessons helped to shape me as a lawyer and indeed as a human, and I'm forever grateful for the opportunity to clerk for her. Judge Saris has been and is and remains a role model for me, and there isn't a significant professional decision I make to this day that I make without consulting her first. And so it gives me tremendous pleasure to introduce our keynote speaker, Chief Judge Patti B. Saris.
Whoa, what an introduction. So I loved Roger when he was a law clerk with me. He was a young, excited lawyer. I knew he was going to do great things, and he gave me a call and said, would you come down to this symposium? It was a treat to be able to share, now that he is a fully engaged professor and dean, and share with me the passion for criminal justice reform. So I said, great, what do you want me to talk about? And he said, well, it's the 50th anniversary of the commission set up by President Lyndon Baines Johnson. And I said, well, I need to read it first. So he said, fine, I'll send it to you. And he sent me the report, and I clicked it, and it kept printing and printing and printing. and truthfully, it was quite thick as I read it, and I enjoyed reading every page of it, because I had not understood until I read it what a significant work that was. And so this is not only the 50th anniversary of that report, but it is also the 30th anniversary of the United States sentencing guidelines. So it really was appropriate for me to address what I'll call the pendulum of criminal justice since that 1967, over the last 50 years. So I said, well, how long do I have to discuss from then to now? And he said 20 minutes. So I'm going to do what I can, and if we have time afterwards, I'm hoping that we could have a Q&A period, and if not, feel free to shoot me an email. I don't want to go over my period because we have such a great panel coming afterwards. So I did read the report, all 300 pages of it and 200 recommendations. And I just go briefly, I know there are a lot of students here, through some of the highlights that hit me. Certainly this isn't everything, or we'd be here all night, but I just want to go through a little bit about what the report talked about. It recognized the urgency of the nation's crime problem and the depth of ignorance about it. It's essentially for that reason, President Johnson established the Commission on the Enforcement and Administration of Justice. I'd never read it, as I mentioned, but this report provides important insight into how we became the world's largest jailer and what we can do about it. As former chair of the Sentencing Commission, I'd like to emphasize it's former chair, so I do not speak for the commission. But as former chair, I was engaged in the criminal justice reform efforts over the past 6 years to address the effects of harsh mandatory minimum sentences for drug and gun offenses and the challenge of mass incarceration. I was also, and I see Alan Morrison here, because I was reminding him that I've known him since I was 28 years old, just a few years ago. I was a staffer on the Senate Judiciary Committee working for Senator Edward Kennedy in the early 1980s when some of these sentencing changes were being debated. So I hope to discuss the pendulum from the 60s till now. So the roots of mass incarceration began 50 years ago as the country faced rising levels of crime. The Johnson Commission, a lot of these are quotes, and so I'm going to use the original language from the report, which some of it sounds a little outdated to us now. The Johnson Commission began its report with the following poignant statement, literally the first line. The existence of crime, the talk about crime, the reports of crime, and the fear of crime have eroded the basic quality of life of many Americans. It continued, there is much crime in America, more than is ever reported, far more than ever is solved, far too much for the health of a nation. At that time, it reports 1/3 of Americans surveyed in high crime areas said it was unsafe to walk alone at night in their neighborhoods. And I found this statistic startling. 1/3 of the people surveyed said they kept firearms in their houses for protection against criminals. The commission pointed out that young people between the ages of 15 and 24 committed a disproportionate share of the crime. It also found, and some of this language, it wouldn't be said today, but it was definitely a statement. Drug addicts are crime-prone persons. This fact is not open to serious dispute. The commission strongly believed that the increasing violence in every section of the nation compelled an effort to control firearms that contributed to violence, and it was of great concern to the commission the recidivism rate. Roughly 1/3 of offenders released from prison were re-imprisoned, usually for committing new crimes within a 5-year period at both the state and federal level. So what happened? Where did this crime happen? The commission reported that the risks of victimization from rape, robbery, and burglary were clearly concentrated in the lowest income group and decreased steadily at higher income levels. The common serious crimes happened often in the slums of large cities. Their words, while rates of offenses of violence and against property were higher for blacks than whites, they found that the differences were very small when whites and blacks live in similar conditions. The commission was of the view, and they always took this broader perspective, that if conditions of equal opportunity prevailed, the large differences now found between black and white arrest rates would disappear. So called out for more equality in conditions. The Johnson report recommended very broad cast objectives to accomplish, and they're things that you didn't see so much in recent years, people talking about. Let's eliminate social conditions closely associated with crime, like why don't we improve the schools? Why aren't we improving the ability of the criminal justice system to detect, apprehend, and reintegrate into the society those who have committed crimes? Why aren't we using community-based treatment for drug offenders? Why aren't our correctional institutions doing better? Significant for today's discussion, it recommended the abolition of mandatory minimum sentencing in the area of drug trafficking. Just to give you a quick statistic then and now, in 1965, there were about 4,000 drug violators in the Federal Bureau of Prisons, about 18% of the Bureau of Prison population. Now, it's about half of the Bureau of Prisons population, over 50%, and so that puts it around 80,000, just to give you a sense of the dramatic differences between then and now. The average sentence was about 87 months, longer than I actually had expected, so they were pretty rough back then as well. The commission called sentencing less a science than an art. In the final analysis, it said it depended on good judges, but it did decry judicial disparity between judges, saying that your sentence should not depend on a purely fortuitous circumstance, namely the personality of the particular judge before whom the case was coming. It called for the systematic gathering of information to have fairer sentences and to eliminate judicial disparity, including tougher appellate review of sentences. Let me tell you, though, what it didn't call for. Noticeably, the commission did not ask for sentencing guidelines, nor did it call for longer sentences, except for habitual offenders, people we would probably call career offenders today. Interestingly, not long after that, under the Nixon administration, the Congress eliminated most of the mandatory minimum laws for drug offenses. I had forgotten that. So there actually was a response to this report in order to make sentencing more flexible, which is one of the things the report wanted. Now I'm jumping forward a decade, from the 1970s to the 1980s. There was a big swing of the pendulum in just 10 years. Calls for rehabilitation and drug treatment were viewed as liberal pipe dreams. Heroin and later crack and gun violence had continued to devastate inner-city neighborhoods, and political leaders from both parties, including African-American leaders, called for punitive measures. With bipartisan sponsorship, and Senator Edward M. Kennedy teamed up with Senator Strom Thurmond, and in basically a landslide vote, I think it was 100-1, and maybe even by the end 100-0, the Congress adopted in the Senate, and almost similarly lopsided in the House, the Congress adopted the Sentencing Reform Act of 1984, which established the Sentencing Commission, a 7-member bipartisan expert body within the judiciary to establish sentencing guidelines, which went into effect in 1987. Now, I was at that point this young staffer sitting in the back of the hearing room. At the time, I remember that the primary questions being asked was, why should a bank robber in California get a more lenient sentence than a bank robber in Texas? Why should it matter which judge within a courthouse you get? In other words, echoing some of the concerns about judicial disparity that were in the Johnson Commission reports. The goal was primarily was to eliminate unwarranted sentencing disparities. But there was also another goal. It had shifted away from the rehabilitation model almost completely, and it went towards a model of controlling crime, using, quote, more certain, less disparate, and more appropriately punitive sentences. In 1986, soon after the guidelines where the commission was established and guidelines were about to go into effect, President Reagan, and then again in the 1990s, President Clinton, signed legislation imposing harsh mandatory minimums. It did things like 5- and 10-year mandatory minimum sentences based on drug amounts, which were then incorporated into the guidelines, ratcheted up sentences for drug trafficking, and this contributed to an explosion of the federal prison population. Drug mandatory minimums could be doubled in the discretion of a prosecutor and how they did their charging decisions, from 5 to 10 years and 10 to 20 years. By 2014, drug offenders constituted, as I just told you, a majority of the federal prison population. Gun violence was also rampant. In 1994, Reverend Jesse Jackson said, quote, that more blacks had been killed by other blacks in 1 year than had been lynched through history. I got that quote from a recent book put out by Professor Foreman at Yale. In his book called Locking Up Our Own, Professor Foreman describes how inner city communities called out for tougher gun and drug laws, and tougher armed career criminal sentencing laws went into effect with extremely harsh 15-year mandatory minimum sentences. Multiple crimes with a gun could be stacked. That's what they called stacked. So that essentially, and it did happen, not often, but it did happen, first-time offenders could receive as much as a life sentence. Tough mandatory minimum sentences were enacted into law at state levels as well. This was not just a federal phenomenon. While the mood was punitive, I believe that very few predicted the crisis of mass incarceration with its devastating effect on minority communities that was to occur 20 years later, a generation later, with 1 in 3 black men coming under both state and federal court supervision. Although 13% of the country's population, they are 37% of the nation's prisoners. At the federal level, by 2013, black and Hispanic offenders made up a large minority of federal drug offenders, more than 2/3 of offenders in federal prison, and about 80% of those, and this is, by the way, I checked it again, it's been true, it was true in 2016 as well, about 80% of those drug offenders subject to mandatory minimum sentencing. So let me jump again. But now, a generation later, the pendulum has swung again as rates of violent crime have dropped to historic lows. And I'm always a little reluctant to say that because in some cities they've ticked back up again, like what you've been reading about in Chicago. and federal and state prison populations had exploded. The Sentencing Commission took action. In 2011, just after I became chair, we did a study of federal mandatory minimum sentencing. And I have to say, it's a bipartisan commission, people from all different points of view. And there were some members of the commission who believed in mandatory minimum sentencing, and some, like myself, who did not. But we were able to reach consensus. It was a fabulous commission to work on because we were trying to get to agreement. What could we agree on when it came to federal sentencing? And so while there were these different views about mandatory minimum sentencing, we all agreed that the mandatory minimums for drug offenses, like the ones I just described to you, were set too high and applied too broadly. They swept in couriers and street dealers alike. Not just the manager, I mean, I'm dating myself, you know, I always think in terms of the Miami Vice television show. You know, that's what everyone was thinking about. I don't want to ask, all right, so let me ask, of the young people here, have you ever heard of Miami Vice? Yeah, all right, you have, all right. So, I mean, you know, the guys with the motorboats zooming across, that's what people had in mind, but that's not whom these mandatory minimums were capturing. They were capturing low-level offenders, street-level offenders, and mules, that's the people carrying the stuff. And in addition, were they too broad, they created a budget crisis. Now, I strongly believe in our federalist system, and this was one classic example where the states took the lead over the federal government. Facing state budget crises, many states, and I'm going to tell you states like Texas. Anyone here from Texas? Texas, South Carolina, California. There's some Maryland people here, right? Yes, some Maryland people took the lead in reducing prison populations. And when they did that, when they started reducing the sentences and reducing the prison populations, guess what? Crime did not increase. That was an important step. All these public safety concerns, crime did not increase. And when I became chair of the commission, the Federal Bureau of Prisons was literally 37% over capacity. And that meant that its budget was 1/4 of the Department of Justice's budget, 1/4, things that should be going for policing and victims' rights and prosecutors and that sort of state support for law enforcement. 1/4 of that money was going to prison. Congress considered bipartisan legislation to reduce tough mandatory minimums for both gun and drug offenses. And they also introduced bipartisan legislation to try and deal with back-end or reentry programs. There are different parts of a statute, and one that I noticed and was brought to my attention was a statutory mandate for the commission to ensure that sentencing laws took into account prison capacity and to consider the proportionality and fairness of sentencing. In 2014, the commission unanimously, and again in a bipartisan way, voted to make an estimated 40,000 prisoners convicted of drug trafficking crimes retroactively eligible for a reduced sentence of an average 25 months. So in other words, 40,000 people became eligible for a reduced sentence. And I emphasize the word eligible because it wasn't an automatic get-out-of-jail-free card. What it was it went back to the sentencing judge, and the sentencing judge would look at the prison record and look at who the person was. But almost all of them were granted that release. There were very few who were found to be public safety risks. On the first day that it went into effect, 6,000 prisoners were released on the effective date of November 1st, 2015. And I have to say, we staged it in a way to make sure that probation officers could be hired up to provide support at the back end, and also to make sure that there were what we call step-down programming, so people would come back into society. So it wasn't just a dump on the street, because we were so cognizant of the concerns about public safety. The commission also, on its own, retroactively had reduced crack penalties in 2007 and also in 2011. The commission doesn't do it very often, but has a statutory power to make guidelines retroactive. I'm proud to say that the prison population decreased from its peak of $217,000 to about 196,000. So it went from, in other words, 35% over capacity to 17% over capacity. To address public safety concerns, because remember, I keep coming back to the Johnson Commission report. I mean, that was the core. People were afraid. So how do you address public safety concerns? So we have this crack team of statisticians and policy analysts who, just exactly what the commission called out for, gathered and looked at the data from when we made the reduction in the crack penalties, and we looked at the people who got the full penalty versus the people who got the reduction. And what did we find based on data? We found that the length of incarceration did not increase recidivism, did not increase. In other words, there was no more recidivism because these people got reduced sentence. Then we did a bigger study. We looked at recidivism generally, and really an amazing report that if anyone wants to see it online. And what we found is that basically recidivism right now in the federal system is about 50%, which is way too high, over 8 years. On the other hand, we found that the length of incarceration did not have an impact on the amount of recidivism. And you have to be careful when you talk about recidivism, because you have to be careful about whether you're talking about rearrest, reconviction, reimprisonment. So the data is all set out there. We also studied disparity in sentencing between white males and black males. And because that's a huge concern of the Sentencing Commission, not just disparity within a courthouse, but also demographic disparity, and found that black male offenders received, on average, about 19% longer sentences than similarly situated white males still. Some people have criticized this study. So other people have done alternative versions of the study, but no matter how you do the multiple regression analysis, and different statisticians all do these things differently, there is a significant difference still between the sentencing. Bipartisan legislation to reduce mandatory minimum sentences received wide support in both houses, but we ran out of time to fix the statutes in the last Congress. It's one of my regrets that didn't happen before I left. We came so close. And because while President Obama did grant clemency to over 1,700 prisoners, and Attorney General Eric Holder did lessen reliance on mandatory minimums as a prosecutorial tool, there is a limit to what the President, the Attorney General, or the Sentencing Commission can do without statutory change. For example, we studied career offenders, and that is something that's set by statute, as is the Armed Career Criminal Statute. As you all know, elections matter, and I see less hope now for bipartisan legislation. I was so hopeful before. I was little Miss Pollyanna, we're going to do this, and it didn't happen. But there are glimmers of hope. Chairman Grassley of the Senate Judiciary Committee just put in a bipartisan piece of legislation. When I say these bills were bipartisan, that was just the beautiful part of it, like there'd been a tipping point. Everyone from Senator Durbin and Senator Leahy to Senator Grassley and Senator Mike Lee. I mean, there was Senator Cornyn from Texas. There was really more broad scale. And really, since that original Sentencing Reform Act went through, that's how much consensus there was that there was a need for change. Not always on the exact provisions. Don't get me wrong, there was some bitter debates about what should be in it, but at least a sense that things needed to change again. And another glimmer of hope is that I can't remember the last time Congress put in a significant mandatory minimum. So that is not now the first tool that you go to. And so when we have the opioid crisis now, people are talking about it more as a public health crisis, and no one's rushing to add an even tougher mandatory minimum. The courts have initiated many drug courts. That started from the bottom up. Judges were really interested in trying to do something. Judges brought rehabilitation back to the table. There are drug courts happening in many jurisdictions, and many other problem-solving courts, like people dealing with mental health or veterans problems and that sort of thing. An additional emphasis on alternatives to incarceration, people thinking about, once again, about special needs of juveniles, because they're better understanding about the science of the juvenile brain. And many states are continuing to press forward for sentencing reform. So I thought I would sum up with certain key takeaways that at least I myself have from the last 50 years. It sounds like a long time, and I was alive for all of it. So let me just see if you agree. Sentences, particularly in the area of drug trafficking, continue to be, now these are my personal ones, former chair, not currently as chair. Sentences, particularly in the area of drug trafficking, continue to be too harsh and disproportionate to the role many low-level, nonviolent offenders play, largely as a result of mandatory minimum sentencing, which the Johnson Commission denounced 50 years ago. The Johnson Commission recommended using data to support sentencing decisions. To that end, we're hoping that that did happen through the Sentencing Commission. The data is amazing if anyone wants to go onto the website and look at it. Second, fear of violent crime and concerns about drug trafficking continue to play a major role in criminal justice policy. You have to just be in New England, it may be true here as well. The opioid crisis is what you read about every day in the newspapers. The Johnson Commission was right to take a more holistic approach to solving crime issues like better treatment for drug addicts and programming for the juvenile offenders. As I said, only in recent years has rehabilitation come back into the equation, but I want to emphasize that treatment programs need to be effective in protecting public safety to retain public support. Recent statistical studies show mixed results on drug treatment programs like drug courts, and we have to make sure that what we're doing is evidence-based and need to be studied. Finally, mass incarceration has had a devastating effect on all communities, particularly minority communities, which are both under-policed for safety and over-policed for incarceration. I agree with the Johnson Commission's recommendation that habitual criminals should get a longer sentence to protect public safety, but, and this is what we learned on the Sentencing Commission in our report on career offenders, we need to be very careful on how we define these crimes, these 3 strike laws, so that they are not overbroad. We need to consider alternatives to incarceration because of the collateral effects of the conviction themselves. In the long run, though, sentencing policy will not fix the crime problem, and that's where the Johnson Commission report was brilliant. In the long run, it's so easy to have the short-term solutions. In the long run, only better policing and attacking the root causes of poverty will, as true today as it was 50 years ago, will basically result in better crime policy. In my view, policymakers should not waste another 50 years failing to address the root causes. So I want to thank you all, and I don't know if we have time, I'd leave it up to you. 5-10 minutes? Somebody want to ask a question? You being shy?
So, Judge?
Yes? All right.
So you mentioned the opioid crisis and the coverage it's getting. I think, in fact, today the president made a statement about it as well. So there's been a lot of attention paid to it. And many have argued that this public health response to the opioid crisis is exactly what we should have done in response to other crises related to other types of narcotics. I wondered if you had any insight on that observation.
Well, I'm all right, being the Pollyanna that I am, I'm just hoping we've learned a lesson. This Foreman book is amazing, but I agree with its bottom line, which I think people made all these incremental decisions along the line and made decisions on this, that, and the other thing. It didn't understand the impact that it would have 20 years later. And I think that we basically see what happened with the drug sentencing and understand about drug addicts. And so we understand that, yes, you need to put people who sell opioids in jail, but people who are addicts and are selling to support their habit also need the treatment. And so I'm hoping we just learned a lesson as society. That's what I'm hoping. Yes?
Aside from the mandatory minimum problem, I would love to get your assessment statute that created it, do you feel on balance it really did make some important progress?
Absolutely. I mean, the last 6 years, I've never been so proud to be part of an organization because we were able to work prosecutors, people with defense backgrounds, based on evidence, and try and come to good sentencing policy. I think, but I have to say, we like to say we're at the crossroads of the executive, the legislative, and the judicial branches. We're located in the judiciary, but it's a shared power, a shared. If you have an attorney general with a certain point of view, or ultimately it's Congress's decision as to what's the statutory minimum and what's the maximum and that sort of thing, and they can veto our guidelines. So that we're definitely very much in the political fray, if you will. But what we try and do is base our decisions just on the evidence, and I think in that sense we fulfilled some of the promise of what the Johnson Commission wanted. But I also have to say that there's also been at least 9 opinions from the Supreme Court, starting with a case called Booker and coming forward, which basically found there was a Sixth Amendment violation with, this is very shorthand, with the mandatory guidelines, and therefore they became advisory. And so, when I talk the sentencing system that was put into effect in the 1980s is not the same system that we have today, because it was a remedial decision in that by the Supreme Court. So, and we've evolved, and we should evolve. That's what it's supposed to be about. And we hopefully I didn't go through everything we did, but we also looked at immigration offenses and all sorts of other offenses. I've focused on drugs today. Yes. That is a great question, and let me explain why that is. It used to be, is anyone here, I don't want to insult anyone, used to work for the Parole Commission, and it was actually a very professional body, but it happened behind the scenes, behind closed doors, and the view of the Congress was, in my view, we all evolve. I like to say we should evolve as information comes to us. This is crazy. The judge imposes a sentence, and then behind closed doors, the Parole Commission has its own little guidelines as to when they're going to release you. This is not transparent. It's not the sentencing judge. No more. Parole's done. Truth in sentencing. All right, well, so now I've been sentencing for a long time. I've been sentencing people since 1994 in the federal system. And just as I've changed in how I viewed things, people change behind bars, and there's no second look. And that's harsh, there's no chance. I remember I went to a prison, and this guy, now in fairness, he was cherry-picked, by the BOP to meet with us, but he said, I was a bad guy. I had guns and drugs and that sort of thing. He said, but I was 22, and now I'm 40. And he said, I'm a very different person, and he was a model prisoner. He'd done this, that, and the other. He had just sort of done all the programs, gotten an education, and there was no chance to do a second look at that person. And so some of the proposals in here don't bring back the secrecy of the Parole Commission, but they have some back-end programs that if you are a model prisoner, you'll get certain reductions off of your penalty. And that was a legislation put together by Senator Cornyn and Senator Whitehouse. And it didn't go anywhere because the legislation failed, but I wouldn't be surprised if there was legislation that actually passed. There'd be an opportunity for a second look at people. So I think we've learned. It can't go back to the old days where it was all behind closed doors, but we could maybe do more about people who are successful in prison. I don't know whether that'll pass, but it was a serious proposal in the Congress. Yes? Well, let me start off with the biggest problem with the alternatives to incarceration, from my point of view as a federal judge. I have no say in it, okay? Alternatives to incarceration are essentially in terms of just vacating, there is no expungement statute. If you're going to have that felony conviction on your record, even if you aren't incarcerated. Let me just start there. So it is up to the U.S. Attorney's Office to provide an alternative, which was essentially if you do X, Y, Z, then we'll dismiss the indictment. I haven't seen, even under, well, let's just say I haven't seen much progress on that level, at least on the federal side. I'm told there are some that are diverted, but I wouldn't see them because then they never come to me. I think the area where the courts and the Sentencing Commission just did a wonderful report, again, gathering information on alternatives that are happening across the federal districts. And what's happening, like, let me tell you, in Massachusetts, what's happening is we have something called the RISE program, and we take people who are either deprived as a youth of certain opportunities, or people who are primarily addicts, and we say, and with very low criminal histories, and usually nonviolent, I think exclusively nonviolent, and we say, if we give you these 17 hoops to jump through, you get your education, you go to a job, blah, 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 you know, you will have a good shot at a non-incarcerative sentence. And we've just started that program, and programs like that are happening all over the country. The judges are being very cautious about it. I mean, they're not giant programs, but they're just little bites trying to see if this will work. And so I think there's experimentation happening on alternatives. But for the most part, I think it's been an initiative on the state level more than it has been the federal level. But read this report because it's a really interesting. There are thousands of reports on the commission, but if you're interested in alternatives, they've tried to, in a qualitative way, analyze the different kinds of programs that are happening across the federal system. Yes?
What are you hoping to see from prosecutors going forward, especially in light of the fact that our Attorney General currently wants to sentences gone after, especially from the U.S.
What am I expecting to see?
What are you hoping to see from prosecutors?
Well, let me just say this: we don't even we have an acting U.S. attorney, so I think what's I was going to call him Senator Sessions. Attorney General Sessions did is he went back, he revoked the Holder memo. I'm sort of getting into the weeds a little. He reinstated a memo which says charge the maximum readily provable crime. So I think that it's gone back to what it was before Attorney General Holder. I haven't yet seen it in action, so I'm not quite sure how it will all play out. But I just will have to take a you'll have to invite me back here in a couple of years. So so I'm hoping. So you'll invite me back, huh, Roger?
Absolutely. Anytime, Judge.
Thank you.
And Judge, I wanted to give you a small token of our appreciation for your being here. So at some point when you're on the bench, and I know you wear the robe, but hopefully under the robe, one day you'll don the GW Law School 150th Anniversary Vineyard Vine scarf to accompany your don. So thank you so much.
Thank you. I will certainly do that in the cold weather in Boston underneath that winter coat. Okay,
Thank you,
thank
Judge.
you.
Thank
Love
you.
it.